Protecting Students from Discrimination in Washington Public Schools. An overview of discrimination and complaint procedures. This training provides a basic introduction to school employees' responsibilities under state and federal non-discrimination laws, identifying and reporting student-on-student discriminatory and sexual harassment, preventing discrimination in school programs, activities, and services, discrimination complaint procedures. This training is a brief introduction to these topics. For more in-depth information, please review the resources listed at the end of the presentation. While many of the civil rights protections and complaint procedures discussed in this training also apply to employees, this training focuses on the rights of students and the responsibility of school staff to prevent and protect students from discrimination. While this training will not cover employment discrimination, you can learn more about your rights as an employee regarding discrimination in the workplace by reviewing the district's non-discrimination and sexual harassment policies and procedures. You can also learn more about the protections against employment discrimination by visiting the Washington State Human Rights Commission's website or the U.S. Equal Employment Opportunities Commission's website. All school districts and charter schools must provide students with equal access to all programs, activities, and services without discrimination. Discrimination is unfair or unequal treatment of a person or group because they are part of a defined group known as a protected class. In the school setting, discrimination can occur when a person or a group is treated differently or denied access to school programs or services because they are part of a protected class. Discrimination can also occur when a school or district fails to accommodate a student or employee's disability. Harassment is when it is based on a protected class, and sexual harassment can also be forms of discrimination. To be unlawful, discrimination, harassment, or unfair treatment must be based on a protected class. A protected class is a group of people who share common characteristics and are protected from discrimination by federal and state laws. Protected classes in Washington schools include sex, race and color, religion and creed, national origin, which can include the language that a person speaks, disability and the use of a service animal, sexual orientation, gender expression, gender identity, which includes transgender students and staff, veteran and military status, which generally refers to employment. The protected classes listed on the screen focus on non-discrimination laws regarding students in public schools, specifically those listed in Chapters 392-190 of the Washington Administrative Code, which is noted at the top of the screen. This includes all of the protected classes listed in education-related civil rights laws, including Chapters 28A.640 and 28A.642 of the Revised Code of Washington, and the protected classes under federal law. In some contexts, local, state, and federal laws cover additional protected classes. For example, federal employment discrimination laws also prohibit discrimination on the basis of genetic information. The Washington Law Against Discrimination additionally prohibits discrimination in employment on the basis of age and marital status. Some city and county ordinances include additional protected classes. During this training, we will focus on two common types of discrimination that may impact students. First, discriminatory harassment and sexual harassment. And second, discrimination in access to school programs, activities, and services. For information on other forms of discrimination in schools, you may review the resources listed at the end of the presentation. First, we will cover discriminatory and sexual harassment. Harassing conduct is a form of discrimination when the behavior is based on a student's protected class and creates a hostile environment. First, discriminatory harassment is based on a protected class. Let's refresh ourselves on the list of protected classes we covered earlier: sex, race, color, religion, creed, national origin, sexual orientation, gender identity, gender expression, disability, use of a service animal, veteran or military status. Next, it creates a hostile environment for the targeted student or other students, such as bystanders. A hostile environment is created when conduct is so severe, persistent, or pervasive that it limits a student's ability to participate in or benefit from any of the school's programs or activities. Note that harassment must be severe, persistent, or pervasive. The harassing conduct does not need to be all three. For example, one incident may be so severe that it alone creates a hostile environment. How might harassment limit a student's ability to participate in or benefit from a program or activity? Here are some points to consider. Are the student's grades suffering because of the harassment? Is the student having difficulty concentrating? Has the student had to drop a class or change academic plans? Is the student feeling increased anxiety about coming to school? Is the student increasingly absent? Does the student feel unsafe at school, at recess, in their athletic program? Is the stress of the harassment impacting the student's relationship with friends, family, teachers, or peers? Is the student reluctant to participate in extracurricular activities or athletics out of fear of harassment? As school staff, you may already be familiar with the school or district's harassment, intimidation, and bullying, or HIB for short, policy and procedure, which covers any student-on-student bullying. It is important to keep in mind that harassing conduct can be both bullying and discriminatory harassment. If harassing conduct is based on, related to, or motivated by any protected class, the district must respond and investigate under both procedures HIB and discrimination. Let's review some of the differences between bullying under the HIB policy and discriminatory harassment. A key distinction between bullying and discriminatory harassment is what the conduct is based on or motivated by. Bullying can be based on any characteristic, including, for example, height or weight. That same type of behavior can become a form of discrimination when it is based on a protected class. The school's response may differ depending on whether the behavior is bullying or is also discriminatory harassment. When addressing bullying, the school's response might be limited to disciplining the perpetrators. When addressing discriminatory harassment, however, the school's response must often be more systemic in nature and extend beyond disciplining the perpetrators. The school must take steps to stop the harassment, eliminate the hostile environment, prevent it from reoccurring, and remedy its effects on any students impacted. Two different district policies and procedures apply. The HIB policy and procedure, which provides for a building-level complaint with a short investigation timeline, and the sexual harassment and non-discrimination policies and procedures, which provide for a district-level complaint with a longer investigation timeline, which can help uncover school climate and systemic issues. And different district-level coordinators may be involved. As it relates to bullying, the HIB coordinator. As it relates to discriminatory harassment, civil rights coordinators, Title IX coordinators for sexual harassment, and Section 504 coordinators for disability discriminations may be involved. Remember, if harassing conduct is based on, related to, or motivated by any protected class, the district must respond and investigate under both HIB and discrimination. Student-on-student sexual harassment is also a form of discriminatory harassment. Sexual harassment occurs when a student is subjected to unwelcome conduct or communication that is sexual in nature and that creates a hostile environment. Conduct is considered unwelcome if the student did not request or invite it and considered the conduct to be undesirable or offensive. The age of the student, the nature of the conduct, and other relevant factors affect whether a student was capable of welcoming the sexual conduct from a peer. A student's submission to the conduct or failure to complain does not mean that the conduct was welcome. An example: consider a situation where a female high school student willingly kisses a male student on one occasion. When the male student subsequently attempts to kiss her again, she objects, but he kisses her anyway. This subsequent kiss is considered to be unwelcome, even though the student welcomed the first kiss. Next, the conduct must be sexual in nature. This can include, for example, unwelcome touching, making sexual jokes, spreading rumors or making suggestive remarks, pressuring a person for sexual favors, distributing sexually explicit text, emails, or photos, physical violence, including rape and sexual assault. Next, the conduct creates a hostile environment for the targeted student or other students, such as bystanders. As we covered earlier in the presentation, a hostile environment is created when conduct is so severe, persistent, or pervasive that it affects a student's ability to participate in or benefit from the school's programs or activities. As public school employees, we have a duty to respond to discriminatory harassment and sexual harassment. If a school knows or should have known about discriminatory or sexual harassment, it must investigate to determine what happened, and if the school finds that harassment has occurred, take prompt and effective steps to stop the harassment, eliminate the hostile environment for the targeted student and any other students impacted, prevent the harassment from recurring, and remedy the effects of the harassment on the targeted student and any other students impacted. The school must take these steps regardless of whether anyone has filed a complaint or asked the school to take action. When are we on notice? The school has notice if a responsible employee knew or in the exercise of reasonable care should have known about the harassment. Who is a responsible employee? A responsible employee includes any employee who has the authority to take action to redress discrimination, who has been given the duty of reporting incidents of discrimination or any other misconduct by students to the Civil Rights, Title IX, or Section 504 coordinator, or other appropriate school designee, or whom a student could reasonably believe has this authority or duty. Whether an employee is a responsible employee will vary depending on factors such as the age and education level of the student, the type of position held by the employee, and consideration of both formal and informal school practices and procedures. As an example, it may be reasonable for an elementary school student to believe that a custodial staff member or cafeteria worker has the authority or responsibility to address student misconduct. First, let's look at when an employee is considered to have known about harassment. For example, staff hear about the conduct indirectly, such as through a news report or community gossip. A staff member witnesses the harassing conduct. A student or parent shares concerns with the principal, teachers, or other school staff. A student or parent files a complaint. Next, when should staff be aware of harassment, even if they didn't witness it directly or receive a complaint? Examples include harassing conduct is occurring during activities under staff supervision, such as during recess, in the classroom, or in the cafeteria. Students are referred for discipline for harassing conduct. Graffiti, such as racial epithets in public areas such as a restroom stall or lockers. Harassing conduct is happening openly in the hallways or during school activities. If a student comes to you to share information about discrimination that they have experienced, there are a few helpful steps to remember so that you feel prepared. First, affirm the student's decision to share information with you. Second, inform the student of your role and obligations to report of student services and the district's prohibition on discrimination using age-appropriate language. Then report to the Civil Rights Compliance Coordinator, Title IX Coordinator, or Section 504 Coordinator as appropriate. When affirming the student or parent's decision to share their experience with you, affirm them by listening without judgment and supporting them by responding to their disclosure appropriately. For example, I'm sorry you're going through such a difficult time. I am so sorry to hear about your experience. And what would be helpful to you right now, especially during an initial disclosure of an incident which the student may have experienced trauma? School staff do not need to interview the student at the time of their disclosure. Generally speaking, the initial report is not the time to determine if what occurred is true, but to affirm the student in sharing the information and trusting the school staff to share their experience. Your most important role is to act as a bridge between the student and the school administrator or civil rights coordinator. If you are a responsible employee, in addition to affirming, you should also inform the student of your role and reporting obligations. Be forthcoming about this when the student or with the student from the beginning helps them understand what will happen next, and that as a teacher administrator, you are not betraying their trust by reporting up. For example, thank you for coming to me with this. I want you to know that in my role as a teacher, I need to share with what you told me with the principal, and I cannot keep it completely secret. It is also important to inform the student about the school's prohibition on discrimination and the support services available to the student. In age-appropriate terms, inform the student it's not okay for any student at this school to be treated differently based on their sex, race, national origin, or abilities. For parents or older students, explain that the district has a discrimination complaint procedure to ensure that concerns of discrimination are investigated and addressed. Provide a copy if you have it available. If not, either follow up to provide a copy or inform the compliance coordinator so that they may provide the procedure promptly. Inform the student that the school has counseling or other support services that may be available to talk to. When possible, refer the student using the counselor's name and telling them what will happen next. School staff should promptly report the student's disclosure to the appropriate district level coordinator. Overall, if you are not sure how to respond to a student's report, it's all right to say something like, "What you're sharing is important and I want to make sure I give you the right information. Can I talk with you again later today?" And then quickly contact the coordinator to get the right information to share with the student. Regardless of what it's labeled or what you perceive it to be, if harassment or bullying is based on any protected class, the school district must assess it for civil rights implications. The label used to describe an incident does not determine how the district should respond. Rather, the nature of the conduct itself must be assessed to determine if the discriminatory or sexual harassment. Remember, even if the behavior is already covered under the district's bullying policy, the school district is responsible for taking prompt and appropriate action to investigate and address discriminatory and sexual harassment, which may require a more extensive investigation and additional remedies. Let's take a look at a scenario. A principal receives a written bullying report. It appears to be related to a student's race. What should the principal do? A. Investigate under the district's HIB procedure. B. Ask the civil rights coordinator to investigate potential discriminatory harassment under the district's non-discrimination procedure. C. Inform the complainant that their complaint will be investigated under both procedures HIB and non-discrimination. Or D. All of the above. The correct answer is D. All of the above. Under WAC 392-190-059, staff must notify the civil rights coordinator when a HIB complaint indicates possible discrimination, or if during a HIB investigation the district becomes aware of potential discrimination. Under WAC 392-190-065, when a district receives a complaint alleging discrimination, the coordinator must provide the complainant with a copy of the district's discrimination complaint procedure and ensure that the district conducts a prompt and thorough investigation into the allegations. After investigating, the civil rights coordinator finds that 2 student athletes used racial slurs toward another student during a pep rally. The students are in several classes together. What actions could the school and district consider? Remember, the school district needs to take a comprehensive approach to address discriminatory harassment. This includes taking steps to stop the harassment, eliminate the hostile environment, prevent harassment from recurring, and remedy the effects of the harassment. Actions that the school and district could consider: disciplining the perpetrators, offering counseling or academic support to targeted students, developing a safety plan, excusing harassment-related absences, particularly if a student missed school to avoid the harassment, conduct a school climate survey to determine the extent of a hostile environment, provide staff training on how to identify and respond to harassment, planning school or district-wide anti-harassment activities or discussions, disseminating complaint procedures to students, families, and staff, strengthening the student handbook and code of conduct, and make sure students are informed the racial harassment will not be tolerated, hosting community dialogues, and other actions. After recess, a student shares with their teacher that another student touched their private area. What should the teacher do? The teacher should thank the student for sharing the information with them and affirm that type of behavior is not expected or permitted at school. The teacher should tell the student that they will need to tell the principal about what the student shared and that the principal may want to talk with them too. It may be helpful to remind the student that if the principal asks to talk with them, that does not mean that they are in trouble for sharing that information with the teacher. If available, the teacher may offer the student the opportunity to talk with the school counselor or another support person, and the teacher or principal should contact the compliance coordinator. Other considerations for the teacher: consider age-appropriate language in the response. It is also helpful to make a note of the instruction covered following this type of report, as the student may not be in a space to take in the information. Also consider any needed accommodations, such as extension or due dates for related assignments. If you suspect that a student is experiencing discriminatory or sexual harassment, please contact our compliance coordinators. When in doubt, discuss with a compliance coordinator. In the beginning of the presentation, I shared that I would be focusing on 2 common types of discrimination that may impact students: discriminatory harassment and sexual harassment, as well as discrimination in access to school programs, activities, and services. Let's move on to access to programs and services. Each student must have equal access in any program, activity, or service the school offers. This includes academic programs, extracurricular activities, transportation, and athletics. We need to make sure our schools do not deny or limit any student's participation because of a student's sex, race, creed, religion, color, national origin, which includes a student's or parent's limited English proficiency, sexual orientation, gender expression, gender identity, disability, or use of a service animal. Some programs or activities have entrance criteria. For example, many sports teams have a cut policy based on skill. Prerequisites and entrance criteria are allowable so long as the criteria are justified by the nature of the program or activity, are applied equally to all students, and are subject to modification when necessary to avoid discrimination, such as providing disability-related accommodations, allowing a student to take an entrance exam in their home language. Schools may not, for example, categorically deny admission to a program because the student needs English language development services, special education, or health services. Here are just a few examples of how we can ensure students have equal access to our programs and services. First, we must make sure our schools allow students to benefit from all programs, including highly capable programs, advanced placement, and career and technical education, regardless of race, sex, language, or disability. We must make sure our schools provide accommodations, aids, and services for students with disabilities when needed. We must make sure to administer discipline fairly and equitably. We must provide equitable athletic opportunities for girls and boys. And we must provide language services for English learners and parents with limited English proficiency. Because this training is only a brief introduction, we will not be going into detail on each of these topics. You can learn more about these topics and more on OSPI's Equity and Civil Rights webpage. If you suspect that a student is experiencing discriminatory or sexual harassment, please contact our compliance coordinators. When in doubt, discuss with the compliance coordinator. The final topic we will cover in this presentation is discrimination complaints. What does a discrimination complaint look like? 1. It can be anything in writing, including by mail, email, fax, or hand-delivered. It can be sent to any school or district administrator. And it is anything that alleges discrimination or describes something that would be a violation of non-discrimination laws, rules, or guidelines. This includes any allegation of unfair treatment or harassment based on a protected class. Anyone can file a complaint, including students, parents, employees, advocates, and community members. A formal complaint does not need to include the word complaint. It simply must be in writing. What do you do if you receive a complaint? Report to the Civil Rights Coordinator immediately. The Civil Rights Coordinator will coordinate an investigation and must respond to the complainant within 30 calendar days. Next, make sure the complainant receives a copy of the complaint procedures so that they can understand the process. Under WAC 392-190-065, when a district receives a complaint alleging discrimination, the coordinator must provide the complainant a copy of the district's discrimination complaint procedure and ensure that the district conducts a prompt and thorough investigation into the complaint. The district may establish a complaint filing deadline. This deadline must be 1 year or longer from the date of the alleged discrimination. Once the district receives a complaint, it triggers the complaint procedure. The district has 30 days to conduct an investigation, complete an investigative report, and respond to the complainant with the results of the investigation and any corrective measures the district will take. These requirements are outlined in WAC 392-190-065. The school district and the complainant can agree to extend the 30-day deadline. Under rare circumstances, the school district may also extend the deadline if exceptional circumstances related to the complaint require an extension. Once the district investigates, the written response must include a summary of the investigation results, whether the district has failed to comply, notice of the complainant's right to appeal, including where and to whom appeal must be filed, any corrective measures needed to correct the noncompliance. Such corrective measures must be put in place as quickly as possible, but no later than 30 calendar days after written response issued, unless otherwise agreed to by the complainant. The complainant can appeal the school district's decision to the school board. After the school board's decision, the complainant can file a complaint with OSPI. At any time, the complainant can also file a complaint with the U.S. Department of Education or the Washington State Human Rights Commission. Please review the following policies and procedures for more details and specific timelines. For more information on any of these topics and more, please visit the OSPI Equity and Civil Rights Office's website or the U.S. Department of Education Office of Civil Rights website.